Hello, my name is Mary Moore, and I'm a member of the League of Women Voters. Today we are pleased to have a panel of nonpartisan candidates for the Court of Appeals, Division II, District 2. The League is a nonpartisan, nonprofit political organization open to all over the age of 18. The League influences public policy through education and advocacy. One of our primary roles is to help the individual voter to be informed, hence today's candidate forum. The League would like to thank TCTV once again for their enduring support for our forums. We so appreciate their expertise and assistance in bringing these forums to you, the voter. Today we have, starting on my left, Brendan Williams, Thomas Bjorgen, Jim Foley, and Mike Lynch, Tom Weaver, and Pam Loginsky. All six are candidates for this important post, and we will start with each one of them giving an opening statement, and following that, I have several enticing questions for them to respond to. So, Brendan, if we would start with you, please.
Well, thank you first to the League of Women Voters for hosting this event. Hello, Thurston County. Thank you for having elected me for 6 years to serve as your state representative. I'm now running to serve 6 years on the Washington Court of Appeals. Currently, I work as a deputy insurance commissioner to State Insurance Commissioner Mike Kreidler, a predecessor of mine from the 22nd District, representing you in the legislature. Prior to having been a state representative and having my own private practice, I ran the Washington Healthcare Association. I'd been its attorney. I was a judicial law clerk for the Washington Supreme Court. I've been very pleased to be endorsed in this race by over 15 organizations, legislators from all 6 counties that I'm campaigning in, and 2 retired Chief Justices of the Washington Supreme Court. Having had the experience of clerking at the Washington Supreme Court, I feel that I am capable of doing this task of working as your judge on the Court of Appeals. And I think importantly, as your neighbor, it's important that those who have spoken against injustice, as I have, are those that you trust to deliver justice on the courts. And I can think of no greater expression of our democracy than the court system, where any 12 citizens have the opportunity to sit in judgment of the most powerful corporation or of the actions of their state or local governments. That is an awesome responsibility. It is a pure expression of democracy, and it is why I am running for the Court of Appeals, and I'd like to have your support. Thank you.
Thomas?
Thank you, Mary. I'm Thomas Bjorgen, and I'm also a candidate for Washington State Court of Appeals. What I'd like to do in this opening segment is to give you an idea of what I think the proper role of the Court of Appeals is. I think in our system, more than any other branch of government, the appellate courts, when they do their job properly, can almost function as the conscience of the country or of the state. And that's because they have in their care those foundational principles that make this country truly something to be proud of. Principles like the freedom of speech, the freedom of religion, the idea that everybody is of equal stature under the law, the idea that everybody is entitled to fairness under the law. Does the system always work well? No, it stumbles sometimes, it makes mistakes. But it's important to remember that that is the ultimate goal, this notion of a just and principled and humane application of the law to the facts. And that's something worth fighting for. So we need judges who will have the courage to make their mind up on the basis of legal principle, not politics, not special interests. We need judges who will always remember that everyone is of equal stature under the law. But we also need judges who will observe proper judicial restraint and who will not step over that line into the legislative sphere and start striking down laws simply because they disagree with them. That's not the role of the courts. But above all, We need judges who will remember that that elusive notion of justice underlies everything that we do here, and that justice is not justice if it depends on who you are or whom you know or the size of your bank account or the weight of your influence. As your judge, those are the principles I would do my utmost to serve. Thank you.
Thank you. And now, Jim.
I'm Jim Foley, and I'm running for the Court of Appeals Division 2. I'm asking for your vote. I'm asking because I hope you feel the same way I do. I've been in court nearly every day for the last 25 years. I know all the law, constitutional law, criminal procedure, civil procedure, tort law, family law, all of it. I believe I'll be a very, very good judge. I won't just be tough on crime. I'll be smart on crime, pushing for specialty courts like drug courts, DUI courts, courts for veterans and those with mental health issues. But that is not enough. There is so much wrong in society today. Corporations committing crimes without sanctions, big banks acting like the law doesn't apply to them, the rich getting richer, and the poor getting poorer. The courts are not a meaningless bystander to all of this. The courts have an essential role to play in making the world a better place. My daughter teaches English. She loves teaching English, but she laments that she made way more money as a bartender than as a school teacher. Something is wrong. And if the governor and the legislature refuse to act, my friends, in the end, it will be up to the courts. And that's why I'm running. Together we can make this world a better place. Together we can begin to right the wrongs. This is my pledge to you. I'm Jim Foley, and I hope you'll give me my vote. And if you'd like to know more about me, see my rap on YouTube. It was written and performed by my daughter. Thank you.
Mike.
Thank you, Mary. I'm Mike Lynch. I've been practicing law in Washington for over 31 years. During that time, I've tried cases to juries. I've handled hundreds of appeals before the State Court of Appeals, our Supreme Court, and the Ninth Circuit Court of Appeals. I have a broad range of legal experience. During the first 7.5 years of my career, I worked in the criminal justice system. I represented the Parole Board, the Correction Standards Board, the Sentencing Guidelines Commission. I have a comprehensive knowledge of how that system operates. I've defended hundreds of criminal cases from constitutional challenge. I then spent the next 7 years of my career trying cases in the torts division of the Attorney General's office. And then after that, I spent another 7 years teaching as a trial team leader other attorneys how to try cases. For the last 11 years, I've worked as the head of the appellate team. At any time, I oversee 50 to 70 active appeals before the state courts of appeals and the federal courts. What I want to bring to the Court of Appeals is my knowledge and experience. It goes also to governmental law. I've represented all of the large state agencies in government, most of the small ones. I've represented the legislature and the courts. That's important in this position because the judge that you elect will be responsible for seeing whether government officials are operating in compliance with the laws and Constitution of our state. I'm Mike Lynch, and I'd like your vote. Thank you.
Thank you, Mike. And now, Tom.
Thank you. My name is Tom Weaver, and I would submit that the job of the appellate judge is to judge the decisions of other judges. And a person who undertakes that role should have at least 3 traits. First, he or she should be experienced. Second, balanced. And third, trustworthy. I am experienced. I'm an experienced appellate and trial lawyer. I've argued over 300 appeals in all 3 divisions of the Court of Appeals and in the Supreme Court. And I've handled between 400 and 500 jury trials on a great variety of issues. I can join the Court of Appeals with my proverbial sleeves rolled up, ready to go to work. But having experience in the courtroom should be a prerequisite, but it's not enough. You need to be balanced. 19 years ago, when I started my legal career, I was a full-time public defender, and I expected I would do that for the rest of my career. I have a passion for justice to ensure that everyone has access to the courts, regardless of race, gender, or ability to pay. My career has taken some other turns, but my commitment to these principles has not changed. as evidenced by the fact that I work with Kitsap Legal Services, a pro bono legal service that provides services to the citizens of this area. And finally, I am trustworthy. I'm a trial lawyer. I'm in court almost every day. I was in court this morning. The judges know me. They know my character. They know my intellect. And I have more endorsements from judges than anyone else in this race, certainly more endorsements from Superior Court judges. And in fact, in my home county of Kitsap County, I have the unanimous endorsement of every single Superior and District Court judge. I am experienced, I'm balanced, I'm trustworthy. My name is Tom Weaver, and I'm running for the Court of Appeals.
Thank you, Tom. And certainly, last but not certainly least, Pam.
Thank you, Mary. My name is Pamela Loginsky. I'm the staff attorney of the Washington Association of Prosecuting Attorneys. I've argued over 100 cases in the Court of Appeals and the Supreme Court. I also clerked at the Court of Appeals. This taught me the inner workings of that court. Using that early training or apprenticeship, I went on to do considerable amount of trial work, criminal, mental health commitments, dependencies. By every objective standard, I'm well qualified to be on this court. That's the conclusion reached by the Washington Women Lawyers, Tacoma-Pierce County Bar Association, Cardozo Bar Association, and the Washington Association of Prosecuting Attorneys, who've all given me their highest rating of exceptionally well qualified. More importantly, I'm someone who believes in public service. I served my country as a United States Navy hospital corpsman. I served the state of Washington by instructing police officers in search law so as to protect all our constitutional rights, and by my membership on the Supreme Court's Pattern Jury Instruction Committee. I've served your community as a deputy prosecuting attorney. I'm an accidental lawyer. I was led to the practice of law through early volunteer work with battered women. I worked as a medical laboratory technician throughout law school so I could help to protect vulnerable individuals as a prosecuting attorney. I'm not an ivory tower appellate lawyer. My current position, I take and translate complex appellate court rulings into rules and concepts that police officers can apply every day at the roadside. I'll bring this unique and proven talent to every appellate decision I will author. It's important that appellate judges remember that every appellate court brief represent a story about real people, people whose lives have been put on hold while court case is pending. I'm committed to limiting the disruption by deciding cases as quickly as humanly possible. I am Pamela Loginsky, and I would appreciate your vote.
Well, thank you all very, very much. We'll open with the questions now, and we'll start with Brendan. And my question to you, Brendan, you have 2 minutes if you need it to respond. And then each one of you, I want you to answer the same question. You'll have 1 minute. This is an easy one. We're going to start out with an easy one, and then they'll get a little tougher as we go along. So, Brendan, what made you choose to run for the appeals court rather than one of the others?
Well, I think that the appeals court is really fitting with my abilities, having clerked for 2.5 years at the Washington Supreme Court. I was encouraged to take on this challenge by a number of folks who are very interested in justice on the Court of Appeals. And as I said earlier, I'm very pleased to have the endorsement of 2 retired Chief Justices of the Washington Supreme Court. To have been a law clerk is really to have seen the process of giving advice to, in that case, all 9 justices of the court, and Division II it would be 7 judges, on the merits of cases, and to write what are called pre-hearing memoranda concerning the parties' briefs, to then draft the opinions. And so I know how that work proceeds. And I've worked on cases ranging from administrative law to murder. I've written 3 law review articles on criminal justice. I've really made it my business, I think, to try to explain justice to people in terms that they can understand, including my column this past Saturday in the Everett Herald on 2 recent decisions of the Washington Supreme Court. I don't think we want justices or judges to be aloof from the public that they represent. And so I'm out there interacting with people and putting up my signs in people's yards, not in the right-of-way, because I'm out there communicating with them about the qualities that they would like to see in a judge of the Court of Appeals. And I think that that is profoundly important, and that is why I'm choosing to run.
Okie dokie. Thomas.
Thank you. The work of a trial court is different from the work of an appellate court. A trial court is involved with basically finding facts and to some degree applying laws. An appellate court is focused entirely on the application of law. And that is what drew me into this. The work that I've done in my 30-year career has focused on exactly that. It has extended to the United States Supreme Court, where I wrote briefs on behalf of the state of Washington in 3 cases in the U.S. Supreme Court. I've also argued cases in the Federal Ninth Circuit Court of Appeals, in both divisions of Federal District Court in the state of Washington, and in the State Court of Appeals and the State Supreme Court. That reflects what is needed in an appellate court judge, that impartiality and that, I think, incisiveness of analysis. And that is what I would do my best to bring.
Okie dokie. Jim?
Yes. It was destiny for me. I come from a big Irish family. I have 5 brothers and 1 sister. They're all attorneys. 3 of them are judges. That's what we do, us Foleys. Besides that, I've been a judge judge pro tem here in Thurston County for 12 years. I was the law clerk to Judge Brian Tollefson and Judge William Brown back in Superior Court back in the 80s. I've been in court virtually every day for the last 25 years. It's my life and what I do. I'm one of those crazy people who keeps rules of evidence in the bathroom when I read. That's all I do is live and breathe the law. Not only that, but I come from a history of volunteering. I was a Peace Corps volunteer in Papua New Guinea, and then I was on the board of the YMCA as well as the Thurston County Bar Association. So serving in the public is what I do, law is what I love, and that's why I run. Thank you.
Okie, and now Mike.
I argued my first case before the Washington Supreme Court 30 years ago. I really fell in love with the appellate process. That's probably why I've been the head of the Torts Division appellate section for the last 10 years. The thing about appeals is when you're not there in the trial court, you're looking over what has happened. You're applying the law to the facts. And I have a very solid background in governmental law, which is something that really is lacking on the Court of Appeals at this point in time. That knowledge I would bring with me to the Court of Appeals to help decide cases, again, as I mentioned earlier, on whether government is operating in compliance with the law. Thank you.
Okie doke. Jim?
Tom.
Tom, I'm sorry.
As I understand the question, it's actually 2 parts. The first part is why run for judge at all, and the second part is once you've decided to run for judge, why run for the Court of Appeals? As I stated earlier, the reason why I'm running for judge at all is because I have a deep commitment to access to justice. I have a deep commitment to ensure everyone is treated with respect in the courts. I've done that as a lawyer, and I have the experience to take that and do it as a judge. The second part of the question is why on the Court of Appeals? I had a conversation with Judge Jay Roof, who's a Kitsap County judge in last December, who has endorsed me. Excuse me. And I discussed with him whether I should run for Superior Court or Court of Appeals, and he told me that my talents lay in the Court of Appeals. I have a desire to learn new areas of law and apply them, and the Court of Appeals affords me that opportunity. Thank you.
Okie dokie. Pam?
Thank you. I decided I love appellate practice. I have handled hundreds of cases on a wide variety of issues. Judge Robin Hunt, the other judge that represents Division II, District 2, encouraged me to run at this time. We are in a period of profound change on a number of criminal procedure matters. Search law fundamentally changed. Confrontation clause fundamentally changed. Sentencing law fundamentally changed. I've been on the ground helping to implement the new rules, and Judge Hunt thought that I could bring those talents to this area of law right now and help it develop in a way that is easily implemented both at the roadside and in the courtroom.
Thank you. Thank you. Now we're on to question number 2, and Thomas, it's your turn at that. As a candidate for the appeals court, what degree of experience do you assign to prior experience with court cases? And please explain.
We all bring different packages of experience to this campaign. And part of deciding whom one should vote for is looking at those different sets of experience. To answer the question, I think that actual courtroom experience on both the trial court level and the appellate court level is really essential to knowing how to do this job and how to do it well. Without the on-the-ground experience at the appellate court level and at the trial court level both, it really is difficult for a judge at the appellate court level to know what that record means, what those words mean that are brought up from the trial court level. Appellate court judging is not a sterile, bloodless exercise. It is not simply a matter of reading the cases and trying to apply them to the facts that have come up from the appellate court, from the trial court, excuse me. It's essential to have that knowledge of what happens at the trial court and to have actually gone through it in order to be able to understand fully what is going on, what is being presented to you as an appellate court judge. As far as my own experience goes, I will bring that out as the questions go on, but let me mention one aspect of it. For 12 years, I have been a hearing examiner for various cities and counties at the local level here in the state of Washington. That has required making decisions in the same way a judge would make decisions at the administrative level. So for those decisions, which now are probably approaching 150, I have seen how these records are generated, how the trial courts make their decisions, and that is essential to being able to be a good appellate court judge.
Okie dokie. And Jim, your response?
Yes. I think we all have to remember that law doesn't occur in a void. We all bring our life experiences to the courtroom, and I have great life experiences. Not only have I been in the Peace Corps, but I've sailed around the world under sail. I've worked in the Olympics and wildfire crews, worked on offshore oil rigs. I've also been a judicial assistant in Pierce County Superior Court for 4 years. I've been in private practice, and I've represented small business owners for almost 20 years. I've represented port districts and all of their related issues, whether it be trains or tugboats or airplanes. Currently, I represent a great variety of small business owners and businesses in downtown Olympia and in Mason County, and they all have concerns that need to be met. When I first started practicing law in Pacific County, I was what was called a family lawyer, but that didn't mean I did family law. It meant you were the family's lawyer, and you did everything for them, from probate to adoption, marriage, divorce, land acquisition, all of it. I've been counseling small businesses and regular people for almost 25 years, and that's what makes me qualified.
Okie dokie. And on to you, Mike.
The broader your knowledge of the law, the better appellate court judge you'll be. So if you have a knowledge of criminal law, you'll know how to decide the criminal cases, the same with the civil cases. But knowledge of the law is not all it takes to be an appellate court judge, because you first apply the law to the facts and determine whether or not an error occurred in the case or not. But then you have to go on and you have to decide whether the error that occurred, whether it prejudiced the outcome of the case. If you haven't actually tried cases and seen how juries react to things, to know the rules of evidence and how they apply and how they shouldn't be applied, you don't really know whether an error had any real impact on the ultimate resolution of the case. I would bring my experience to that on the Court of Appeals.
Tom, what degree of importance do you assign to prior experience with court cases?
Thank you. As I said in my opening, I believe that experience in both the appellate courts and the trial courts should be a prerequisite for anybody that you consider for this job. And the reason is as Mr. Lynch just alluded to, you need to have perspective on what it really means. I've always said that being a trial lawyer made me a better appellate lawyer, and being an appellate lawyer made me a better trial lawyer. When something unusual happens in a trial, and it doesn't matter how well I prepare for a trial, something always unusual happens. I can recognize that something unusual, first of all, has happened, and second of all, what it means. And when I'm doing an appeal and I see that something unusual has happened, I can look at it and say, wow, something unusual happened, and the trial lawyer either did or did not respond appropriately, because my perspective allows me to do that. With over 300 appeals and 400 to 500 jury trials, I have the experience to do that. Thank you.
Okie doke. Pam?
I clerked at the Court of Appeals, and this taught me how the inner workings of the court. I've also handled trial cases, had to respond to those last-minute changes and snafus, and I've also been an appellate attorney handling hundreds of cases, leading to more than 100 published opinions from the Washington Court of Appeals and Supreme Court. All of those are important requisites. Court of Appeals handles approximately half their caseload is criminal. I have the criminal law experience. I have experience with something called personal restraint petitions, these collateral attacks that many of my colleagues don't have. A number of cases that come to court, but most importantly, as a prosecuting attorney, you are a quasi-judicial officer. You are the only type of attorney who owes a responsibility to your opponent sitting across the aisle. I have worked as hard and as tirelessly to protect the rights of criminal defendants as I have crime victims, and I would bring that skill to the appellate court.
And finally, Brendan.
I think it's about quality and not quantity. If you look at the past on our Washington Supreme Court, for example, Jim Dolliver, who is a very distinguished judge on that court, served 22 years, 2 as its Chief Justice, was a member of my church, First United Methodist Church of Olympia, with his wife, Barbara. He did not have trial or appellate experience in being appointed to the Washington Supreme Court, but he had the aptitude to be a great judge, a fact recognized by the fact that there's a building named after him today in downtown Olympia. 2 retired Chief Justices of the Washington Supreme Court feel that I have the ability, as evidenced by my clerkship there, to provide unerring advice on cases. It is about quality, not quantity. Thank you.
Okie dokie. We are on to question number 3. And Jim, I believe it's your turn.
It is.
Yes. So, what one thing in your experience has best prepared you for the position of appeals court judge?
I don't think you can put your finger in any one thing. If you've been practicing law for 20 plus years and tried hundreds and hundreds of jury trial cases, I could point out maybe a case I took up to the Supreme Court several years ago where there was no law in Washington, but every other jurisdiction, every federal court, 30 of the states had decided the issue, but it was brand new in Washington, and yet I felt it really should be the same as everywhere else because it was well-reasoned decisions on the federal court level. And I took this case here to Thurston County Superior Court and lost. I took it to the Court of Appeals Division 2 and lost. I took it to the state Supreme Court, and 15 minutes after I argued my case, they came back unanimously in my favor and granted the relief that I was requesting, and it became law in Washington. And that's what you have to do if you want to be an appellate lawyer. So I would say all of my 20 years of experience, but also taking a case from the trial court level through the appellate process, being knocked back by judges, and keep persevering up to the Supreme Court and setting new case law has got to be one of the big moments. Thank you.
Okie dokie there, Mike. What one experience?
Thank you, Mary. I don't know that I can state one experience either, and my entire career has helped to prepare me to be an appellate court judge. But I think it's working in the community on different organizations with people who aren't lawyers that gives me a perspective that many people don't understand the law, and they don't like the law. And the reason they don't like the law, I think, is because they don't understand it. There may be a reason for why the law is there, and I think everything I've ever seen about a good judge is a judge who takes the time to explain in very simple terms what the decision is and why it's being made. And I think that is an important quality for any judge, especially one on an appellate court.
Okay. It's up to you now, Tom.
Thank you. I've spent every day of my professional career representing everyday people with everyday problems. And having the perspective of seeing those problems on a day-to-day basis is something that is valuable to me both as a human being, because it helps round me out as a human, but it also helps round me out as a potential appellate judge. Dealing with people who have methamphetamine addictions, like the person that I saw just this weekend who was arrested last week, or dealing with people who have severe mental illnesses, like the person I dealt with this morning in court. Dealing with domestic violence perpetrators and domestic violence victims, and the dynamic that unique relationship brings. Walking into a jury trial, like I did earlier this spring, with a client that I honestly thought was going to assault me with his pen at any moment. That gives me a perspective and a balance in the courtroom. Thank you.
Pam?
I also bring my whole life with me, including volunteer work with battered women, illiterate adults, handicapped children. One of the most important things that prepared me for this position, though, is teaching at the Washington State Patrol Academy. Right now, 46 men and women form the 100th Academy class, and I'm proud to be their legal instructor and translate those complex legal concepts into things that individuals can apply at the roadside. And I think that's helped prepare me to write opinions differently than I would have if the only background I had was being a clerk at the court or even being a trial attorney. It helps me see how to apply the concepts in real people's lives.
Okay, good. Brendan?
I think being responsive to citizens for 6 years as a state representative is probably my most valuable experience. Obviously, as a judge, you're going to be called upon to interpret enactments of the state legislature. And really in my work going around the community now in this campaign and putting up yard signs, I put up over 300 here in Thurston County myself, and talking with supporters like Nancy Armstrong, whose Eastside Women's Health Clinic was burnt down by an anti-abortion terrorist years ago. And I enacted legislation to protect her insurance coverage and have the support now of Pro-Choice Washington. I think that that's the kind of experience that really matters in a race like this, being able to identify with everyday citizens.
Okay, and up to you, Thomas.
Thank you, Mary. Let me give you an example of one case which I had, which I think illustrates this point and answers the question. My first job as an attorney was as an assistant attorney general for the state of Washington. One of my clients was the state library, and I was told this would be a quiet agency. It would never need much in the way of legal advice. A group called the Moral Majority made a public records request against the state library for circulation records. They wanted to know who had been checking out a certain film. In those days, the Public Disclosure Act did not have an exception for library records. And so I was told by my superiors that I needed to disclose. After I did the research, though, looked at the First Amendment and its case law, it seemed to me that it would be a travesty under the First Amendment for the government to start disclosing these records. So I advised the state library not to disclose. We were sued by the Moral Majority, and just before we went to court, they withdrew their lawsuit. It's one of the most satisfying things I've ever done.
Thank you. Thank you. All right, are you ready?
You bet.
All right. How much deference to sister divisions as a Court of Appeals judge are you required to pay? Are you required to rule in line with other divisions? In other words, do other courts of appeals divisions set precedents for you?
Yes. Other divisions of the Court of Appeals do set precedent because there's actually only one Court of Appeals. It's broken into 3 different divisions. So as a judge in any division of the Court of Appeals, you're required to treat any other decision as controlling precedent. That doesn't always happen, but it should. Or if you're going to distinguish a case from what another division has done, you need to be very clear as to why you're doing that, because that's one of the primary criteria upon which our state Supreme Court takes review when there's a conflict between different divisions of the state Court of Appeals. The Court of Appeals really needs to, there are conflicts within divisions of the Court of Appeals. You'll see one panel of judges come out with a decision that's different from another panel. That should really be avoided at all cost, because the law has to be applied uniformly and consistently in order to be fair. You can't have one party coming before one panel of the Court of Appeals and another before another panel and getting a different decision.
Okie dokie, what do you think, Tom?
It's a difficult question. I had the experience a couple years ago of arguing two cases in Division 2 of the Court of Appeals, State versus Jackman and State versus Zimmerman, which I addressed the exact same issue. And I got two different three-judge panels with Judge Bridgewater on both panels. And in one case, I won 3-0 in a decision written by Judge Bridgewater. And in the other case, with the exact same issue, I lost 2-1 with Judge Bridgewater dissenting. That was within one division. Now the question is, what happens when you add two other divisions? I believe that there should be a mechanism in a very small percentage of the cases, and it should be very small, where the court can sit what lawyers call en banc, where they sit as one, where they can decide issues within themselves. Justice should not depend upon the randomness of which three judges get to hear a particular issue. There should be uniformity, and there's no mechanism right now to do that, short of going to the Washington Supreme Court.
Thank you. Pam, what do you think?
There is only one Court of Appeals. It has 22 judges scattered between three divisions. And the important thing is that each of those judges faithfully discharge their oaths of office and work together to reach compromise when necessary, to disagree when required, for that higher court to make the decision. I think I'm the only one of the candidates who served on the Practice of Law Board, which sits in panels and reaches consensus agreements, and on the Washington Pattern Jury Instruction Committee, where the whole goal is to find the law, determine the law, and announce the law for the lower courts to apply in all those jury instructions and trials. And we bring diverse backgrounds. And I'm pleased to say that I've been able to work with people across the aisle to reach the decision that the law requires, not necessarily the one I would like to see.
Okay, thank you. Brendan?
I think a real concern is that there's not enough precedent coming out of the Court of Appeals to defer to. Too much of the work is done in the form of unpublished opinions, which don't have precedential authority. And I think that's a reflection of the fact that at a time when the other sectors of state government, particularly here in this state government town of Olympia, are pressed to work harder, the Court of Appeals isn't working as hard as it could. And I'm not running to be a dynastic successor to any Court of Appeals judge. If you look at the courts.wa.gov website, Division 2 has actually been the least productive of the three divisions when it comes to issuing opinions. And I think I would provide more assistance to my law clerks and probably a little less time on the golf course were I to be a Court of Appeals judge.
Cool. Thomas?
Thank you. I think Mr. Lynch's remarks really encapsulated well the answer to this question. I do have to say, though, I disagree with what we've just heard from a couple other candidates. I don't believe that the en banc approach, which means having every judge sit on every case or certain cases, is a very good solution. That only is going to take more time from the Court of Appeals. It only is going to put more of a burden on the court's budget. I have to say, too, that I disagree what we just heard about the implication that judges are spending too much time on the golf course. That is simply not the case. These judges on that division work hard, and that has to be recognized. I think that type of attack on the Court of Appeals is not productive. And instead, we have to think of things that we can do to make the work of the Court of Appeals more efficient and to save taxpayers' money in this branch of government.
Okay, now you have the last word.
The last word. There's a difference between binding and persuasive, but I think judges have a right and a duty, actually, to challenge laws that they think are wrongly decided. And I'm not going to use a Washington case. I'm going to use a much bigger case. It's called Citizens United. And it's a case that came out of the U.S. Supreme Court in the last several years, and it changed law, hundreds of years of law, on basically a political precedent. And it decided that corporations were people. Well, my friend, I'll tell you, I'll believe corporations are people when Texas executes one. Okay? But now what happened is Montana came out just last month with WTP versus Montana, where they said, hey, that law doesn't apply to us because we have our own special laws. And those judges in Montana, they weren't saying we're not being bound by the Supreme Court. They're saying we're different. And judges and lawyers have a right to say that and a right to push for new law. Thank you.
So, Tom, what has prepared you to resolve civil issues among government agencies?
Well, first of all, let me concede that compared to some of my colleagues, I probably have less experience than some of the others in terms of resolving civil issues between government agencies. However, I have a strong interest in learning new areas of law. In fact, Ms. Loginsky and I had a case just recently, State of Washington versus Tracer, which dealt with issues involving statutes that were passed when Washington was a territory and that had never been interpreted in Washington State. And so we had to go and we had to research how other states had dealt with similar issues. It dealt with very interesting issues about the power of a judge to appoint a special prosecutor. And what I found was that doing the research in that it was really like a history lesson, a mini history lesson into one particular area of the law. And that's part of what attracts me to being an appellate judge, is that every single case that comes along allows me to learn a new area of the law. Sometimes areas like in the Tracer case that I would never have thought that I would ever be researching. And so that's part of the reason why I'm in this race. Thank you.
Pam, what is your response?
Prosecuting attorneys, in addition to prosecuting criminals, represent all of the different branches of government in the courthouse. That means the auditor, the assessor, the county commissioners, the treasurer. And in my role as staff attorney at the Washington Association of Prosecuting Attorneys, I assist our civil practitioners, and that frequently requires mediation between one player in the courthouse and another player in the courthouse when they disagree. I also have drafted legislation to help resolve conflicts between counties and state and between different branches of government, and I would bring those proven talents to the Court of Appeals. Thank you.
Very good. And Brendan?
Well, I think as a legislator, you very oftentimes have to act as a referee between different state agencies. And certainly now as a deputy insurance commissioner supervising the regulatory division of the Office of the Insurance Commissioner, I oftentimes see conflict between different state agencies. I think I've also been able, though, as a private practice attorney to resolve some of that conflict, including, for example, when a class of my clients was facing the possibility of a very significant retroactive tax increase based on a change of interpretation by the Department of Revenue, and I was able to negotiate a settlement for them with the state that saved them at that time was estimated to be in excess of $30 million. Never had a client condemn me for keeping them out of a courtroom. That was always something that they enjoyed, frankly, and so I think that that's an important quality to have too.
Thomas?
My work as an assistant attorney general and as a deputy prosecutor involved precisely this, helping to solve disputes among branches of government. In later time, I've gone into mediation, serving as a mediator, and as I suppose you know, mediation is a situation where two parties who are at odds get together with a third party neutral, and that mediator tries to find common ground that will keep them out of court and that will lead to a resolution that is acceptable to both. That's been a very satisfying part of practice. I've also been part of 3 separate statewide negotiating groups, one dealing with the Growth Management Act, the GMA, another dealing with shorelines, and another dealing with forest practices. These statewide groups were aimed at seeing if the various disparate interest groups involved could find some sort of common ground in a very sharply disputed area. I'm happy to say in each of those situations we were successful.
And finally,
Jim.
not finally, Jim, not finally.
I'll tell you that
That's
I've been
one
what's called a port attorney for over 20 years, and in my 20 years of doing that, I've represented the ports of Shelton, the Port of Willapa Harbor, the Port of Peninsula, the Port of Ilwaco, and the Columbia River Ports Association. And in my work with the Columbia River Ports Association, talk about negotiating with a bunch of different government agencies. There's the state of Oregon, there's the state of Washington, they each have a Department of Ecology, and there's the Army Corps of Engineers who think they're the boss. And we would have fights all the time, and there'd always be threats of lawsuits. And I came up with a program, and I said, look, from now on, we all agree, before we do anything, 30 days in advance, we'll all write each other a letter and tell them what we're going to do so we can talk about it. And the Army Corps of Engineers thought that was such a brilliant idea that they gave the colonel for the Portland Army Corps of Engineers an award. And I wanted to take credit for that because I'm the one who came up with the policy of just telling everybody what we're going to do before we do it.
Mike.
I didn't write that question, but I will say that my 31 years as an assistant attorney general has prepared me quite well to address conflicts amongst state agencies. The last thing the people of the state of Washington want to see is 2 state agencies in court suing each other. That should be avoided at all cost. That's not to say that it doesn't ever happen. It does sometimes because each agency has a position on a point of law that needs to be decided by a neutral and detached court. Usually those types of cases get decided in the state Supreme Court. But working with the agencies to try and resolve those sorts of conflicts ahead of time takes a deep understanding of the law that applies to both agencies. You get together with them and you work through that, and if you need to, you go to the governor because the governor is over most state agencies, and that's how you get it resolved.
Okie dokie, guys. Well, we have one last question, and Pam will take this one. And it's a relatively easy one, and I think a fun one, probably. And that is, we would like to know, what judge have you particularly admired, and why?
I particularly admire retired Chief Justice Richard Guy, and I'm incredibly proud to say he's an endorser. But I respect Chief Justice Richard Guy because he was a centrist. He totally understood the roles of the 3 branches of government and respected them in his opinions. But more importantly, I liked his community work. Richard Guy was one of the justices who got community domestic violence conferences going and brought people to the table who weren't there when I first started working to address the problem of domestic violence years ago. Also, Chief Justice Richard Guy understood that if you got people to the table, you could make changes. And I have, over the years, represented the state of Washington in a number of capital cases. We didn't have court rules addressing this, and every time you seem to be making it up from whole cloth. I also can't think of two parts of the Bar Association more polarized. And Richard Guy got us all to the table, sat us down, and it was amazing the fact that you could produce court rules that have made the process both fair and a little more transparent to the community than it was beforehand. And so that's the judge I most respect.
How about you, Brendan?
Well, I think it's an easy answer. For me, it would be retired Chief Justice Gary Alexander of the Washington Supreme Court, for whom I clerked and also had the opportunity to be an extern for on 3 Division II Court of Appeals cases. Justice Alexander began his service in 1973 on what was called then the Thurston Mason Superior Court, and his service only ended last year when, under mandatory retirement, he was arbitrarily forced to retire, because the presumption is at the age of 75 you can no longer be a Supreme Court justice. I'm very proud to have his endorsement. The fact that Justice Alexander was first appointed to the bench by a Republican governor, to this day, as a private citizen, remains a Republican, but never brought that to his work as a judge in the same fashion that I did not bring my partisanship to my work as his judicial law clerk.
Thank you. Thomas, how about you?
Thank you. I would answer that by mentioning 2 U.S. Supreme Court judges who are very contrasting, Justice Douglas and Justice Harlan. I think Justice Douglas showed an approach to the law that recognized that sometimes our ancient guarantees that are over 200 years old need to be expanded, need to be interpreted to meet the new circumstances which are being presented every day. And Justice Harlan, on the other hand, was somebody who met the law with great intellectual rigor. Justice Harlan would probably not have agreed with Justice Douglas too often, but they both brought these different aspects which are essential to appellate court judging. And I'd also like to mention the judge whom we are all running to replace, Judge David Armstrong. He also has a stellar record on the Court of Appeals, and I'm proud to say that Judge Armstrong has endorsed me, along with Mr. Weaver, to succeed him.
Okie dokie. Jim?
A word is not a crystal, transparent and unchanged. It is the skin of a living thought, and may vary greatly in color and content according to the time and circumstances in which it is used. That's Benjamin Cardozo, and he was a Supreme Court justice, and if he can write like that, he's got to have my vote. Thank you.
Okie dokie. Mike?
I guess my favorite Supreme Court justice was John Paul Stevens. When he was first on the court, he was viewed as a moderate. As the composition of the court evolved, he was viewed as a liberal. But what I appreciated the most about Justice John Paul Stevens is the fact that he always adhered to the rule of the law. He was a collaborator and someone who could work together with the other justices on the court to achieve a result that was fair. If you've practiced law very long, you know that the law does not always achieve justice. It takes great skill to be able to harmonize the two. And that's what I admire the most about Justice John Paul Stevens.
Okay.
You know, for me, it's actually a difficult question because every judge brings something different to the table. I agree with almost every judge on some things, and I disagree with them on some things. But Justice Brennan used to tell his law clerks that the most important constitutional principle was the rule of 5. Because in his mind, it didn't matter whether you were right on the law or wrong on the law. If you couldn't get 4 other judges on his Supreme Court of 9 to agree with you, you were going to lose. Well, on the Court of Appeals, we sit in panels of 3, which means that if you can't get at least one other person to agree with you, then you're not going to be able to put forward your principle. It means you have to be able to work with other people, you have to be able to compromise, you have to be able to persuade sometimes very intellectual and very hard-headed people. And I think that's an important principle that Justice Brennan brought to the table.
This has been an absolutely great little lesson for those of us who are not as familiar with the courts as you people are. Now is the time when each one of you will have a chance to give a kind of a wrap-up And I'd like to give you simply 1 minute to do that, since we have run over a good deal of time. And why don't we start with you, Pam?
Thank you. Thank you. Again, I am Pamela Loginsky. I'd appreciate your vote. I am someone committed to public service, and I would like to serve you in this new way. I have served your community in the military, trainer of police officers, deputy prosecuting attorney, special deputy prosecuting attorney. I'm endorsed by the Thurston County Prosecuting Attorney John Thunheim, by the Thurston County Sheriff's NAZA, by the Thurston County Deputy Prosecutors Union. I'm endorsed by numerous judges at all levels of court from across the state, including retired Supreme Court Justices Charles Smith, Bobby Bridge, Faith Ireland, and Richard Guy, and by Thurston County District Court Judge Kayla Wilcox. I promise to serve you tirelessly and fairly and justly. I'm Pamela Loginsky. I'd like your vote. Thank you.
Thank you. And Brendan?
Yes, I'm Brendan Williams. Thank you for this time. I would love to have your support, having served you for 6 years in the State House, with one of my earliest childhood memories being living in low-income housing in West Olympia. I'd like you to check out my website, brendanwilliams2012.com. If you have any questions about my campaign, my phone number is 360-791-3979. And I promise complete transparency. You want a yard sign? I can give you that. You want my resume? I can provide that. You want my business and occupation tax returns for the time that I was a legislator? I can provide that as well. I would love to have your vote. My name is Brendan Williams.
Thomas?
In my opening remarks, I spoke of the purpose of the judicial system, this notion of a just and principled and humane application of the law to the facts of the case. This demands broad legal and life experience. As I mentioned, I have served as an Assistant Attorney General for the state, as a Deputy Prosecutor for Thurston County, and for the last 13, 14 years, I have been a partner in a private law firm in the city of Olympia. As I mentioned, my appellate experience is extended to the United States Supreme Court and has involved argument in virtually every other level of the court system. I've practiced law for over 30 years. I've represented individuals, businesses, nonprofits, and governmental entities. I think this gives the knowledge of both the law and of life. But you don't need to take my word for that. As I also mentioned, I think, I've been a hearing examiner for 12, 13 years. That has generated a written record of impartial and fair decision making. You can look at what I've done, not just what I'm telling you. I'm Thomas Bjorgen. Thank you.
Jim?
I'm Jim Foley, and I'm asking for your vote. I'm not just a lawyer. I'm a father, a boat builder, and a cook. I memorize poetry to keep my mind sharp. I've tried well over 200 cases and been practicing law for more than 20 years. I've tried cases at every level of the court system in Washington. I was the law clerk to Judge Brian Tollefson and Judge William L. Brown. I've sailed around the world, been in the Peace Corps in Papua New Guinea, and fought wildfires in the Olympics. I'm a well-rounded, well-experienced attorney. I'll bring experience, wisdom, and knowledge, and most of all, I'll bring common sense to the bench. See my rap on YouTube, Jim Foley Rap. You'll like it. Thank you very much.
Mike?
Thank you, Mary. My family has practiced law in this community for over 100 years. I dedicated my career to public service, serving the people of the state of Washington. I want to take that work to the next level, to be your judge on the State Court of Appeals. I'm respectful. I have the temperament to be a good judge. I have the knowledge and experience to do criminal, civil, and governmental cases. And I'd like you to judge me for yourself by looking at my website, mikelynchforjudge.com. Compare me to the other candidates, and I'd like your vote. Thank you.
Okay, Tom?
Thank you. I'd like to conclude with some comments, not written by myself, but written by an individual that I have tried many cases against. Earlier this year, in my home county of Kitsap, we had a judge pass away, and Governor Gregoire appointed a gentleman by the name of Kevin Hull to replace him as Superior Court judge. Judge Hull, when he was a senior deputy prosecutor at the Kitsap County Prosecutor's Office, he and I tried many cases together, and some of them were very, very complex, difficult cases. And Judge Hull endorsed me earlier this year with the following comments. Tom is battle-tested in our trial courts and has proven his mettle. Tom will bring with him to the Court of Appeals an impressive wealth of appellate success. Tom is a tireless worker and has a passion for justice. I can't think of anything better to say. Thank you.
Well, thank you all. Thank you all. This has been a delightful experience for me. You are all superb candidates, and we have appreciated your time today. Again, the League would urge all of you to make sure that you vote. That is the most important thing you can do if you live in a democracy. Vote, and vote. Make sure that you vote knowledgeably for all of the races, not some where you might know somebody or not. And I hope this candidate forum has helped you in determining some of the most important races that we possibly have, those races for our court system. Thank you very much.